In this petition, the SRC's prolonged inaction allowed the benefit to accrue, thus became one of the terms and conditions of service for judges. Judges have been appointed since 2011 and have been enjoying this benefit since then. By parity of reasoning, the benefit acquired constitutional protection under Article 160 sub Article 4, and for that reason, the benefit cannot be taken away, as this would amount to a variation of judges' terms and conditions of service to their disadvantage. We therefore find and hold that the SRC's prolonged inaction, coupled with the enjoyment of the benefit by judges for a long period, sanctioned the reviews contained in the two circulars dated June 2nd, 2015 and 4th June 2018, and the benefit acquired constitutional protection under Article 160 sub Article 4. In conclusion, having regard to what we have said above, we have arrived to the following conclusions. First, this court has jurisdiction to hear and determine the petition. This is because Article 160 sub Article 3d Roman 2 of the Constitution confers on the court jurisdiction to determine whether anything said to be done under the authority of the Constitution or any law is inconsistent with or in contravention of the Constitution. The petition challenges the constitutionality of the action taken by the Salaries and Employment Commission, which had nothing to do with the employer-employee relationship. Second, the taxable car allowance is a benefit to the office of judge. It was conferred under the retired Constitution as a duty-free car grant, which enabled judges to purchase vehicles for private use. The benefit transitioned to the 2010 Constitution by virtue of Section 6 and Section 6 and 7 of the schedule to the Constitution, as read with Article 210 sub Article 3 of the Constitution as a benefit under Article 160 sub Article 4. Third, the taxable car allowance benefit and subsequent reviews is ring-fenced and protected under Article 160 sub Article 4 of the Constitution and cannot thereby be taken away, altered, or varied to the disadvantage of judges. The position, in view of what we have concluded above, the appropriate orders that commend themselves to us and which we hereby make are as follows. 1. A declaration is hereby issued that the taxable car allowance for purchase of vehicles for private use by judges that existed prior to 12th of July 2021 constitute a benefit payable to and in respect of judges under Article 160 sub Article 4 of the Constitution and cannot be varied or altered to the disadvantage of judges. 2. A declaration is hereby issued that the Salaries and Employment Commission's letter dated 12th July 2021 purporting to revoke the taxable car allowance contravenes Article 160 of the Constitution, is a threat to the independence of the judiciary, and is therefore unconstitutional, null, and void. 3. An order of certiorari is hereby issued quashing the Salaries and Employment Commission's letter dated 12th July 2021 to the extent that it purported to revoke the taxable car allowance for judges. 4. An order is hereby issued compelling the Principal Secretary, National Treasury, and Economic Planning to forthwith process, pay, and continue to pay the taxable car allowance to judges as and when they falls due. And finally, this being a public interest litigation, we make no order as to costs. Thank you.